Ladies and gentlemen, thank you for taking the time to be with us today and welcome to the M&A Academy program and our second webinar in the 2024 series. My name is Nidhi Kilawala and I am an M&A partner in Khaitan's corporate M&A group. I would like to extend a very warm welcome to this webinar to every one of you, whether you are in our audience in India or around the world. The M&A Academy program is designed to provide foundational legal knowledge and understanding on M&A transactions and processes to corporate executives, in-house legal teams, and others participating or interested in M&A in India today. Our subject today is critical issues in private M&A in India today. On this slide is the agenda for today's webinar. In summary, we will have an expert panel discussion followed by a Q&A session with audience questions. We have already received several audience questions, and if you do have more questions, please feel free to submit them using the facility provided in the webinar portal. If we cannot cover all questions during the webinar, we will respond to you offline by email after the webinar. Also, please note that a copy of the presentation, summary notes of the discussion, and a recording of this webinar will be sent to you after the webinar as a matter of course. M&A is an important part of the firm's practice with more than 50 partners dedicated to this area because India is experiencing massive growth in M&A transactions. Today's webinar is important because complex private M&A deal activity in India is a critical part of the overall M&A market. There was a monumental increase in M&A transactions in 2022, and despite global headwinds in 2023, M&A deal momentum has been very robust last year. We are experiencing a strong M&A market in 2024 as well. Even though the regulatory framework has evolved and the market is more mature, M&A transactions in India are still quite unusual and challenging by reason of inter alia, the multiplicity of regulators, interpretational uncertainty, and approval processes which are quite unique to India. It is therefore important for you to better understand the private M&A transaction space, which of course is our objective today through the course of this webinar. Everyone who has registered for this webinar should have received by email already a summary of the panel members and their credentials to talk on today's topic. So I will not spend much time introducing them. Suffice to say that all experts on the panel today are subject matter experts in this field and are very qualified to express their views on these issues. On our panel today, we are joined by three partners from Khaitan's corporate M&A group, Ms. Aishwarya Nagpal, Mr. Pashupati Nath, and Ms. Radhika Agarwal. So now let's start with today's session by speaking to our expert panel members and bringing them into this conversation. My first question is to you, Radhika. What should you do if the seller will not give any warranties or will not give key warranties in an M&A transaction in India?
Thanks, Nidhi. We often see a provision in term sheets that customary representations and warranties will be provided to the acquirer as part of the transaction. The reason why I am highlighting this is that it is almost a given in most of the transactions that I have done. I would say at least 80-85% of the transactions that I have done. I would always look out for this provision in the term sheets, and I've also almost always seen such a provision where either you have a one-line sentence saying customary representations and warranties will be provided, or you have a full schedule of the important representations and warranties. Now, in a situation where the representations and warranties are not going to be provided to an acquirer, or if the company or the promoter, the seller promoter refuses to provide these warranties, is where you see acquirers getting creative and looking for alternate means of securing protection for themselves. Before I delve into the means of securing protection, I just wanted to quickly highlight the types of transactions that we have seen wherein there is some resistance on providing warranties or backing the indemnities for such warranties. The first such example would be a listed company transaction. In that case, there is a lot of material available already in the public domain. There are different parameters that come into play. So in that case, you don't typically see the full suite of representations and warranties being provided. Another such example would be an insolvency transaction, any transaction or acquisition which is undertaken under the aegis of the insolvency laws. In such a case, again, the factors are different, the mechanism is different, representations and warranties and indemnities are not forthcoming from the seller in such a situation. Another example would be something that we are seeing increasingly, where a company is either backed by a majority financial sponsor or it is a professionally managed company. In both of these situations, the seller promoter is not in control of the company, may not be in charge of the day-to-day operations of the company, or in such a situation, the seller probably holds a stub shareholding in the company. Hence, the automatic argument or the automatic position that the seller should not be the one providing the representations and warranties. So, what should an acquirer do in such a situation? The first obvious thing that comes to one's mind is look for what does the law itself provide. So, the law itself does provide certain implied warranties. These are, however, mostly around title. Another related aspect to this would be that while the resistance is on providing business representations and warranties, most sellers are typically okay providing warranties around the title to the shares, providing warranties around capacity, authority to contract, and perhaps a limited set of key warranties around the business, for instance, or around the lack of encumbrances, but not the whole suite of 15-20 page warranties that we are used to in M&A transactions. The next thing that one would be looking at in such a case would also be focusing on an exhaustive due diligence. This is where a due diligence exercise, in fact, assumes a lot more significance, because in a lot of situations where, in fact, a live situation that I am looking at right now, where, as we all know, there's time pressure to complete the transaction by 31st March, our focus is on key diligence matters because we know we are getting an exhaustive representation and warranty schedule. But where you don't have the safety net of representations and warranties is where diligence assumes extreme significance, because that at least helps an acquirer prepare for unidentified, unfactored in risks at the beginning, identify those, distill through those, and appropriately prepare itself for any associated risks, and most importantly, reassess those risks and price the transaction accordingly. The other alternatives in such a situation, again, this is an obvious one. If the seller promoter is not providing you with representations and warranties and it's not a buyout transaction, look to the company to providing with representations and warranties. This works well in a minority where where the acquirer is picking up a minority position. That, coupled with the shareholder gross up, is something where we've seen acquirers typically getting comfortable. Another product which is actually gaining a lot of momentum and which I will be discussing a little later on as part of this discussion would be a W&I insurance product. That is also something which we are seeing gaining a lot of traction. There's a shift in the market trends around that. It is becoming a more attractive product. And what happens in this is essentially shifting the risk to the insurer in exchange, of course, for a premium. The pros and cons we'll get to a little later in the session. So to conclude the answer to this, I just wanted to leave you with one thought from a technical standpoint. And this is something we actually saw one of the acquirers insist on one of the deals that we were advising on, is that from a technical standpoint, to have the remedy of breach of representation and warranty, and also to ensure that the seller promoter has some skin in the game, is to insist that the representations and warranties still come from the buyer, but where the concern come, because the still come from the seller, because at the end of the day the seller is still the promoter of the company. But in that situation, you can agree to the indemnity being passed on to someone else. So it's not the financial aspect, but more so about the legal remedy of having the ability to go behind the seller for misrepresentation, acting as a deterrent value, and like I said, most importantly, having some skin in the game.
Thank you
Over
for
to
that
you.
insightful answer, Radhika. I think the key message there is even if there are no warranties or key warranties that seller is not willing to offer, frankly, that's not the end of the road as far as M&A negotiations are concerned. There are various solutions that can be considered, and frankly, taking from what Radhika mentioned, get creative is probably the way forward for M&A lawyers to think about this. Continuing with the theme of warranties in an M&A transaction, I want to put my next question to you, Aishwarya. What, according to you, is more important in an M&A deal? Is it due diligence, or is it really the warranties and indemnities package, which Radhika just helpfully outlined for us?
Nidhi, I would say the answer is that both are equally important and often not a substitute for each other. Now, the benefit of conducting a due diligence is that the buyer is able to identify risks and liabilities upfront, consider whether it's willing to go ahead with the transaction, and if so, at what price. Diligence findings are often covered by way of conditions precedent, conditions subsequent, purchase price adjustments, or specific indemnities. To take an example, while conducting diligence of a manufacturing company, we actually discovered that one portion of the land on which the manufacturing facility was constructed was under litigation, and the target's title to the land was challenged on the ground that the IBC process pursuant to which the target had acquired the land was not duly conducted, and therefore the acquisition of the land itself was invalid. Now, obviously, this is a fairly serious issue that the buyer needed to know of upfront. Now, because we knew of the issue, the buyer could think of ways of dealing with it. How we dealt with it is that we said the litigation must be settled as a CP and any settlement costs are to the account of the seller. The buyer was also considering other alternatives like requiring the seller to relocate that portion of the facility to a new premises or adjusting the value upfront. Emphasized on the importance of a thorough legal due diligence exercise, it's important to understand that a large part of the diligence is actually reliant on the information that's willingly shared by the target and the fact that diligences are often limited in scope. Therefore, what's uncovered as part of the diligence may not be all of the information necessary to protect the buyer, and that's why warranties backed by indemnities become critical, which effectively cover the buyer for any unknown risks and provide the buyer with a remedy if the statements made about the target company or the business are proven to be incorrect, resulting in a loss to the buyer. Therefore, as I said in the beginning, both are equally important aspects of an M&A transaction. And during the course of this, I think we'll deal into other aspects around this.
Thanks for that, Aishwarya. These considerations are certainly helpful in understanding the importance of undertaking a sound due diligence exercise, as well as ensuring adequate warranties and indemnities in an M&A transaction. It's really the allocation between known and unknown risks, which both of these exercises help us achieve. My third question is to Pashupati. Taking from the points that have been made by Radhika and Aishwarya so far on the importance of warranties and indemnities and a robust legal diligence exercise, it takes us to the next obvious question on disclosure letters and why sellers spend so much time preparing an accurate disclosure letter. Pashupati, why would you say that seller disclosure letters are important in an M&A transaction?
Thank you, Nidhi. I think disclosure letters are a risk mitigating instrument insofar as the seller is concerned. Matters which are disclosed in the disclosure letters, they qualify and act as an exception to the warranties which the seller is providing. Now, if to the extent any matter has been disclosed in the disclosure letter, the seller is not going to be liable in connection with any losses arising in relation to the matters disclosed. Therefore, from a seller standpoint, disclosure letter act as an instrument pursuant to which the seller can de-risk itself in relation to matters which are known to the seller and which may result in a breach of the warranties at the time of preparing the disclosure letter. Accordingly, in my view, the seller should always consider identifying all liabilities which it is aware of at the time of preparing the disclosure letter. Even from a buyer standpoint, We always prefer that the seller discloses everything. The reason is fairly simple. In my view, I would prefer a buyer to enter into a deal with the eyes wide open after knowing all the risks rather than getting informed of the risk post its investment. See, from a buyer standpoint, what happens? Buyer receives a disclosure letter. It has an opportunity to review the disclosure letter carefully. And if the matters disclosed are significant enough for the buyer to reevaluate either the price which it has offered or the protection which it has negotiated in the transaction document, and even in some cases, consider whether it wants to go ahead with the deal or not. For instance, in a deal, we were representing a buyer which is one of the leading players in the fast moving consumer goods space. And the buyer wanted to acquire FMCG business of a seller, which was quite significantly locally placed. The commercial intent for the client was very clear that they wanted to acquire the underlying brand under which FMCG goods were sold by the seller. We did a thorough diligence. Diligence was done and there were no red flags which were thrown up. However, when the sellers shared their disclosure letter, there was one specific disclosure which said that the seller had earlier transferred a separate business to a third entity, and in connection with the transfer, shared had entered into a trademark assignment agreement. Now, copy of this trademark assignment agreement or the business transfer was not made available at the time of diligence. Of course, this does not relate to the FMCG business, so rightly so, they did not provide. But looking at the fact that there was an assignment agreement for the underlying brand, we requested for a copy. And when we reviewed the copy, we realized that under the trademark assignment agreement, the underlying trademark was assigned without specifying the classes, which effectively meant that the seller was not the ownership of underlying trademark even for the FMCG products which it was manufacturing and selling. As I said, for our client, it was absolutely critical that we acquire the trademark. And since the seller did not own the trademark, the deal fell through. Therefore, and to sum up, I would say disclosure letters are risk mitigating tools. Even though they are issued by the sellers, they are equally important for both the buyer and the seller.
Thanks for that, Pashupati. You make a very interesting point that disclosure letters serve as an important tool to provide risk visibility to parties on both sides of an M&A deal. I think oftentimes there is a narrative created in M&A transactions that these are mostly for sellers' protection, but it's, as you rightly said, equally important for buyers to receive a quality disclosure letter as well, so that they know exactly what they're buying and getting themselves into. I think pivoting this discussion to another key issue in private M&A transactions in India today, my next question is to Aishwarya. What, in your view, Aishwarya, are reasonable limitations on warranties and indemnities in private M&A transactions?
Having discussed the key role of warranties and indemnities in M&A transactions, I think it's important to note that these are not a carte blanche for the buyer. So, for instance, in transactions involving multiple sellers, there's always negotiation on whether the warranties are provided on a joint and several basis or only on a several basis. Now, sellers obviously prefer to provide warranties on a several basis, which links their liability to a portion of the purchase consideration that is received by them. Whereas, from a buyer's perspective, the seller should be treated as a group and it should not be the onus of the buyer to pursue distinct remedies against each of the shareholders. What we've seen in such situations is that the sellers, while providing warranties and indemnities on a joint and several basis, often enter into a back to back inter se arrangement which apportions the risk amongst themselves. The other key thing to note is that a buyer is only entitled to claim indemnity for losses, and therefore, how losses is defined becomes very important. Most balanced transaction documents will say that the buyer is entitled to claim indemnity for actual and direct losses suffered or incurred by the buyer and will exclude indirect, consequential, and penal losses. Now, whether indemnity for diminution in value is explicitly provided is another point which is negotiated between the parties. Also, as was previously mentioned, The buyer is not entitled to claim indemnities for matters disclosed to the buyer as part of the disclosure process, which acts as an automatic limitation to the indemnity package. Other limitations to indemnities are in the form of caps in quantum and time. So, for instance, a breach of fundamental warranties may be limited by 7 years and subject to a cap of 100% of the purchase consideration, while business warranties may be limited to 3 to 5 years and capped at about 50% of the purchase consideration. Indemnity claims are also subject to other limitations like de minimis and basket, which seek to protect the seller against non material and multiple parallel claim proceedings. So basically, a buyer can bring a claim against the indemnifying parties only if the claim is above a specified threshold and if each of the claims taken together aggregate to a material amount. These thresholds are often prescribed either as a definite number or or as a percentage of the total purchase consideration. Another typical limitation on indemnity is the duty of the buyer to take commercially reasonable steps to mitigate the losses. Now, these limitations are not absolute, and we'll see that as we go along.
Thanks for that, Aishwarya. I think the a natural extension of that question, then, frankly, is if a seller is going to push for reasonable limitations on warranties and indemnities, then is it really fair to ask the buyer to take the hit for those negotiated limitations on warranties and indemnities? What if something rises to a level that's grave enough? And surely that sort of begs the question that are there carve outs from these limitations on warranties and indemnities that are reasonable and that a buyer should seek to make? And maybe that's exactly the question, Radhika, that we can sort of discuss with you. That would you say there are reasonable carve outs from the limitations on warranties and indemnities that Aishwarya just outlined for us?
Sure, Nidhi. I will answer this question in two parts. In the first part, I will answer what are the typical exclusions to these limitations that we see in the market. And in the second part, how many of these do we actually see acquirers end up getting? Like Aishwarya outlined, while there are several limitations on liability that a seller would seek to include on its indemnity to ring fence itself from, like Ashwara mentioned, multiple litigations, small litigations, etc. But the list of exclusions to such limitation on liability is actually pretty short and is also, if I can take the liberty to say, fast shrinking as per the trends that we see. The first limitation that the first exclusion that you would usually see is for fraud, willful misconduct, and gross negligence. The second bucket I would say would be fundamental warranties. These would include title warranties, warranties on execution authority, capacity to contract. The third bucket I would say would be specific indemnity matters. These are matters which have been identified as risks as part of the due diligence and have been agreed to be specifically indemnified for by the buyer and the seller and are often documented. In addition to specific indemnity matters, there's an allied concept of updated disclosures and deemed specific indemnity matters. So, for any extra risks which are identified for the period between signing and closing, which a seller would typically seek to disclose in its updated disclosure letter, any risks which are identified out of those which the acquirer deems material and depending on the position in the documents agreed upon with the seller, then these are called deemed specific indemnity matters, and these are also typically bucketed with and treated on the same along the same lines as the specific indemnity matters. Now, where do we see these stack up? How do these stack up, and what is the current market trend on these? So, on the first bucket, which was fraud, willful misconduct, and gross negligence, fraud is where parties are usually in agreement. In some cases, I have also seen fraud being left out of the document altogether rather than putting an uncapped an uncapped exclusion to fraud or the seller seeking to cap fraud. I've also seen that. However, I would say that typically fraud is something which is agreed upon by both the parties to be outside of the limitation of liability regime. Willful misconduct and gross negligence, on the other hand, there's actually been strong pushback on recent M&A transactions where sellers are not so keen on having fraud or having willful misconduct or gross negligence being outside of the limitation of liability regime. So what you often see are clear definitions of what is willful misconduct, what is gross negligence, contextualizing these in the case of business warranties. So as opposed to a general willful misconduct, it is in the context of business warranties. And we're also in fact seeing them existing as concepts in the document, but probably still subject to the limitation of liability regime. On the second bucket, which is on fundamental warranties with respect to title, capacity to contract, etc. The second bucket, again, it's a mixed position. In some cases, you see these being completely outside of the limitation of liability regime. In some cases, you see them being subject to caps, albeit slightly higher caps as opposed to the business warranty regime. And it's something Aishwarya also alluded to in her previous discussion point. And the third bucket would be specific indemnity matters. Now, specific indemnity matters, what we are seeing is that it is purely commercially driven. The treatment of specific indemnities, like with fundamental warranties, depends on the risks which are identified as part of the DD exercise and what is the commercial risk appetite of the acquirer, what is the estimated loss, the back calculation that the acquirer would have been doing at its end, whether it really needs to be outside of the monetary caps, outside of the temporal caps, or as with fundamental warranties, you have them being a part of the limitation of liability regime, but you have a slightly higher standard for specific indemnity matters.
Thank you, Radhika, for giving us a detailed outlook on carve-outs from limitations on warranties and indemnities. While we have been discussing the more granular issues in private M&A in India today, it is equally important to look at structuring considerations. Structuring an M&A transaction is often the key to a successful outcome, and parties have to take into account multiple factors and underlying motivations while deciding what is the right structure for an M&A transaction. To this extent, my next question is to Pashupati. Are share acquisitions, in your view, commonly preferred over asset deals as the method of acquisition, or the reverse, and why?
Thanks, Nidhi. I think in short, the answer is no. As you said, right? Structuring considerations take into account various factors, and there are no preferred structures. So neither share acquisitions are preferred over asset deals, nor asset deals are preferred over share acquisitions. However, in our experience, the parties will generally go for a share deal in case where the target company is undertaking a single line of business, in which case it provides flexibility to the buyer in terms of which the buyer can acquire the securities of the target company in one or more tranche. Similarly, it provides a clean break to the seller, where the seller has no liability in respect of the target company except for the indemnity obligation which it may have towards the buyer. However, if the target company has more than one line of business, or the target business itself is housed in an unincorporated entity, say for instance sole proprietorship or a partnership firm, then the preferred mode of acquisition could be a business or an asset deal. We should remember that business or asset deals are relatively more complicated in terms of implementation as compared to a share deal. And this is on account of the fact that business or asset deal will require a buyer and seller to negotiate what assets and what liabilities will be transferred as part of the business deal. In fact, the buyer and the seller will also need to identify appropriate mechanism for transfer of each class of assets forming part of the business or asset. Now, in M&A deal, whether the parties should go for a share deal or an asset deal would depend on various factors. One, which we have discussed, is whether the target company is having one line of business or more. Second, again, we have touched upon, which is whether the target business is housed in an unincorporated entity or even in listed companies, because there are separate considerations. In listed companies, if you go ahead and acquire a significant stake, then you have an obligation to give open offer, and that's where the structuring considerations come into play. Third, could also be relevant is the nature of buyer. Is it a strategic player? Is it a financial investor? Fourth could be what is the intention of the buyer. Do they want to acquire 100% of the target business, or they simply want to acquire a significant stake in the target business? Additionally, one consideration which people have in mind while deciding which structure to prefer is what is the level of contingent liabilities which a target company has. Because at times, if the contingent liabilities are significant and as are identified during the process of diligence, then there may be a situation that the buyer does not intend to inherit those contingent liabilities and therefore they can move away from a share deal to a asset deal. In fact, in various cases where target company is undertaking multiple line of business and the buyer is not intending to acquire 100% of the target business, we have advised the parties to consider a structure which includes both a transfer of business to a wholly owned subsidiary of the target company and thereafter the buyer acquiring an interest in the wholly owned subsidiary. We have seen this structure to be also followed in case of where the target business is housed in listed companies. As I said, if you directly go and acquire a stake in listed company, you may be open to give an open offer, which may not be the case with the buyer. So therefore, in similar situations also, we have seen there are umpty number of examples where we have seen that the listed companies first hive off the business to a wholly owned unlisted subsidiary, and then the investor come and invest in those companies. To sum up, in an M&A deal, there are no preferred structures. We first identify the commercial objectives of the parties and thereafter identify the appropriate structure to give effect to those commercial objectives. Depending upon the commercial objectives, one can prefer a share deal, stock deal, or a combination of both.
Super. Thanks, Pashupati. That was a good overview of the different structures that one could potentially consider in an M&A transaction and what really is the driving force behind structural considerations. Another important issue in private M&A is the increased trend of part payment or deferred consideration transactions. In this regard, my next question is to Aishwarya. How common, according to you, are part payment or deferred consideration transactions? And what are some of the key risks that are associated with such structures?
I would say deferred payment constructs are commonly used as an effective tool to bridge any valuation gaps. Now, typical deferred consideration parameters are linked to a company's performance indicators like EBITDA, volume of purchase orders, or happening of uncertain events, for instance, the result of a litigation that might take place within a specified time period. But one needs to be careful while structuring deferred payment constructs, especially in share purchase transactions involving residents and non residents. The reason I say this is because FEMA regulations allow deferment only of up to 25% of the total consideration and for a maximum period of 18 months. So, for instance, in one case, the seller was expecting a premium to the purchase consideration on account of onboarding of a potential new customer in the quarter following the closing. Now, obviously, from a buyer's perspective, until an actual purchase order is received from such person, the buyer was not comfortable paying the premium allocated to this purchase order. So the buyer and the seller agreed to defer about 20 crores out of the total purchase price of about 100 crores for a period of 6 months. This purchase order was finally received within the agreed time period, and the buyer then paid out this balance amount. In this case, even though the buyer was a non resident, this structure was workable because it was within the 25% and 18-month restriction. Just as a note, these FEMA considerations do not come into play in transactions involving both Indian parties or other structures like a slump sale or an asset sale. The other complexity in a deferred consideration construct is the uncertainty around the taxability of the deferred component. Now, there are conflicting rulings on whether the entire price is taxable in the year of the transfer, irrespective of when and if it is received, or whether it's taxable when the income actually accrues and is received. Yet another view is that deferred consideration is taxable as income from other sources in the year of receipt and not as capital gains. Also, there's typically seller pushback on this construct because obviously sellers prefer certainty of payment on closing itself. To provide additional comfort, buyers can offer to set aside this deferred payment amount in an escrow account or issue an equity commitment letter. Just as a last point and to conclude, to avoid some of these issues, an alternate structure that can be considered is for the seller to retain some stub shareholding in the target, which is then bought out at a later stage at either a predetermined price or a variable price depending on the achievement of some agreed terms, or instead do tranched investments instead of an outright purchase.
Thanks for that, Aishwarya. I think that's a great segue into the next topic that I wanted to pick up with Pashupati, with respect to earnout deals and how they are structured. This, of course, oftentimes we see that deferment is just one of the many ways in which an earnout deal is structured. So, Pashupati, if you could help us understand what exactly is an earnout deal and how are they typically structured in an Indian M&A context?
Thanks, Naveen. To simply put, earnouts are arrangements for the sale and purchase of securities of a company, where part of the purchase consideration is calculated by reference to the future performance of the company being acquired. Earnouts are commonly used, as Aishwarya mentioned, where there is a significant gap in valuation in the minds of the buyer or the seller, or where the buyer intends to incentivize the seller and or senior management of the company towards future performance of the company. Take, for instance, during COVID pandemic, many of the sectors were significantly impacted, and the current performance of the companies operating in these sectors were not truly reflective of their long-term valuation. Now, to deal with this mismatch in valuation, which was on account of an external factor and not reflecting the current operations of the company, several M&A deals were structured to provide additional consideration to the sellers if the future performance of the target company improved and achieved pre-agreed milestones. From a structuring point of view, earnouts are structured keeping in view the intended beneficiary of those earnouts. Typically, intended beneficiary of the earnouts will include sellers of the securities of the company, in some case the target company itself, and in certain cases the senior management of the target company. Depending upon who the intended beneficiaries are, earnouts can be structured by way of deferred consideration, which I'll not delve in detail as Aishwarya has already discussed this in detail. The second option could be staggered acquisition. Now, staggered acquisition is where the buyer acquires part shareholding of the target company upfront, and the remaining shareholding it acquires over a period of time, in which case the determination of the purchase price for the remaining stake takes into account the future performance of the company. The third option, which parties can consider, is an upside sharing arrangement, where typically if the buyer at the time of an exit earns a return over and above the agreed threshold, then the upside is shared by the buyer with the intended beneficiaries. Lastly, the buyer may also consider entering into arrangements for additional compensation with the senior management, in which case the future performance of the company achieving pre-agreed milestones, the senior management are entitled to additional compensation. Now, one last thought on the issue which I would like to share is that often a lot of importance is given to structuring earnouts. But let's remember that it is equally important, at least for the legal advisors, to carefully consider the drafting issues in relation to earnouts, and in particular, three of them. Firstly, what are the earnout milestones? Make sure that the contract clearly outlines what are these milestones, whether they are revenue based, non-revenue based. Typically, revenue based milestones will include, I would say, turnover, EBITDA. Non-revenue based can include, I would say, technical qualifications or regulatory approvals. The second, which is quite important, is what is the earnout period? The length of earnout period should be clearly identified. And in this regard, the party should also consider identifying whether the earnout payment will be a one-time payment or will it be structured in multiple tranches over the earnout period. The third and the most important aspect is what were the interoperating covenants applicable during the earnout period. Because see, this is very important from the beneficiary standpoint that they have some level of operational control in the company in order to ensure that they can propel the target company to achieve those earnout milestones. Similarly, the acquirer which may acquire control of the target entity does not want to give absolute operational freedom to the senior management or to the seller. So there is always a tussle, and there are significant negotiations around these. So therefore, in my view, structuring earnouts are important, and there are means in which it can be structured. But from a lawyer standpoint, drafting considerations are equally important, and they should be given due attention.
Thanks for that, Pashupati. I think as M&E lawyers, having visibility and understanding of the commercial considerations and goals of the parties in entering into an M&E deal is key to successfully representing the client's best interests and effectively negotiating the transaction. My next question then is to Radhika. How do you really protect against value diminution or changes in the business between signing and closing?
It's interesting that you ask me this question, Nidhi, because one of the deals that I was working on actually had a 2 year period between signing and closing. So I can actually take you all through the key protections which we saw play out during this period. One of the most common protections that you see for what we call the standstill period between signing and closing is to actually have a robust set of standstill obligations or interim period covenants as they are called. Now, what are these covenants? These are usually split into two parts. One part would be certain actions which the company is permitted to take without the consent of the buyer, and certain actions where the buyer will be required to weigh in on key decisions. And what is the consequence if this is not adhered to? The consequence, the more important consequence, as I would like to say, would be the ability to walk away. This again differs from a transaction to transaction basis. In some cases, breach of any interim period covenant would give the buyer the ability to walk away from the transaction, whereas in certain cases, you peg it to certain material covenants, and there are of course differences in whether a cure period is available or not, or how would it be determined if there's actually been a breach of such an obligation. Another important point to keep in mind for these standstill covenants is if the underlying transaction requires antitrust approval, requires a notification to the Competition Commission of India, then the list of standstill matters cannot be the usual long-winded, exhaustive list of matters. It needs to be laser focused. It needs to be matters which would be something which pass muster with the Competition Commission of India, and should not be matters which can be seen as the buyer actually already acquiring control over the affairs of the company. And this is what we call gun jumping, which basically is something where before the approval, before the approval has actually come in, before the regulator has actually approved the combination, certain actions are already subject to the buyer's consent. Other remedies for breach of these covenants pre-closing would be something like damages, post-closing would be indemnities. But like I said, the more important consequence what the parties look at, other than these, of course, being of deterrent value, being the commercial agreement being codified in the contracts, is of course the walkaway right. Other ways in which the buyer can protect itself, and not just the buyer, even the seller can seek to protect and seek to provide for provisions to prevent value leakage, would be providing for certain adjustments. There are pre-closing adjustments, there are post-closing adjustments. These adjustments can be done basis the locked box construct. These adjustments can be done basis completion accounts, and like I said, could be either pre-closing or post-closing. And what these essentially do is it helps mitigate a certain amount of risk in relation to diminution in value between signing and closing. As with most of the constructs that we've discussed so far as part of this panel discussion, it is very important to see what the underlying transaction is, because it's not a one size fits all approach. Not every adjustment is allowed as a matter of course for every transaction. Again, depends on the residential status also of the parties involved, because if there is a foreign direct investment involved, and for instance if it's a subscription transaction, then the typical adjustments would not work. Then again you need to get creative with how to make sure that the parties get the economic effect of such an adjustment. Other contractual constructs that we see which help with diminution in value or address value leakages between signing and closing would be the construct of material adverse effect. Material adverse effect is again a point which is hotly debated in most transactions. what the buyer and the seller are seeking to do over there is to essentially ensure that there is a tight definition. From the seller's perspective, there should not be too many outs for the buyer. From the buyer's perspective, the buyer should not be taking on any unnecessary risk. Or, for instance, exactly what the question that we are discussing, if there is significant value erosion, the buyer should not be bound to conclude the deal. How do we see a material adverse effect playing out in documents? You either see it as a warranty, you see it as a condition precedent, or occurrence of an MA would give a walkaway right. And in some cases, you actually see all of these protections in a document. So that would be the construct of material adverse effect. Again, an important construct for protecting against value diminution. Another construct which I touched upon briefly in one of my answers is the construct of an updated disclosure letter. Pashupati has already covered why disclosures are important, so I will not get into that. But this also is an important risk allocation tool, I would like to say, where for the seller is making sure that the warranties are actually subject to certain limitations, and from the buyer's perspective, it actually helps them unearth even more risks between signing and closing. And we see different examples here as well. In certain cases, any updated disclosure letter which is above a certain value threshold would trigger a walkaway right. In some cases, there's a cure period. In some cases, the buyer and the seller are required to discuss. But broadly, these are the constructs that you see which provide protection to the parties for any, or rather helps address any sort of value leakage between signing and closing. Just one important thought that I want to leave you with in this is that it is very important to look at these protections in context, and also most importantly see what is the time gap between signing and closing. If the time gap between signing and closing is not very significant, then one needs to take a considered call on whether all of these protections are actually important. Is there a need to provide for an updated disclosure letter, or the speed of closing the transaction is more important to the parties? Whereas if the time gap between signing and closing is expected to be a huge gap, for instance, the transaction that I was talking about, where there was a 2 year time period, we had of course not anticipated a 2 year time period, but we knew that this would be a significant one. So in that case, all of these constructs that I mentioned, adjustments, disclosures, material adverse effect, interim period covenants, all of these were carefully considered on both the sides, and we did have robust protections for both the sides in the document.
Thank you, Radhika. I'm sure all the points that the panel has discussed today have helped our audience appreciate the nuanced considerations that form part of M&A deal making in India today. Before I move on to audience questions, I wanted to thank our panel and members of the panel here for that insightful and interesting discussion and for their time today. I hope our audience enjoyed it as much as I did. So thank you, members of the panel, for your time in that discussion. Now, I would like to take some questions from our audience. We've received a fair number of questions in the live chat box. So very quickly, I'll take the first one that we have here. Maybe Pashupati, if you could help us with this one. If the question that we have is, if representations and warranties are in place, then what really is the significance of an indemnity package?
Thanks, Nidhi. I believe a breach of representation and warranties per se will entitle any buyer to a claim for damages. Now, the answer lies in the fact that a claim for damages under Indian Contract Act, Section 70, requires host of qualifications for the buyer to meet. Say, for example, then the claim has to be reasonable. Now, rather than getting into the fact that a buyer has to go ahead and establish that it has suffered a damages under Section 73 on account of breach, indemnity is a easier remedy wherein the consequence or the resulted, I would say, loss is compensated on account of occurrence of an event which is pre-agreed, which is here the breach of warranty. So I believe indemnity is a more effective remedy than a claim for damages, and that is the reason why, even though reps and warranties are provided by the sellers, the buyers still seek indemnity in relation to breach of those reps and warranties.
Thank you for that, Pashupati. The next question we have here is on break fees. Are break fees in common use in Indian M&A? And if so, what form do they typically take? Maybe Aishwarya, you could help us answer that question, please.
Yes, absolutely. I think it's an interesting one. I would say that the concept of break fees is not as common in India as it is in other international markets. There's also no benchmark or market standard yet of what the amount of break fees should be. In other more mature markets, break fee is often seen in the range of 1 to 3%. But in India, we don't have a standard yet. Just going back to what the concept of break fees is. So, break fees is when the buyer is entitled to claim damages or losses if the transaction is terminated on account of certain pre agreed events, for instance, breach of exclusivity obligations, delay in fulfilling material CPs, occurrence of an MAE, etc. There's also a concept of a reverse break fees, which basically applies when the buyer terminates the transaction, and this is typically on account of the fact if the buyer is unable to place its funds in time. Now, enforceability of break fees and reverse break fees is not yet well tested in India. But as a general rule, I would say that while negotiating break fee, it should be borne in mind that the amount is calculated as a genuine pre estimate of losses as opposed to being seen as penal in nature. The other reason why break fees is perhaps not so common in India is because the payment of break fees to a non resident may be subject to the prior approval of the Reserve Bank of India, depending on the facts and circumstances. To conclude, I do feel that break fees and reverse break fees will become more popular because it's an important tool to bolster deal certainty and value the significant time, effort, and costs which are spent in reaching deals. We're seeing several cases in the market where parties are dragging each other into disputes on account of the fact that a party has failed to fulfill its obligations on time. So I do think that we will see this more in M&A in India.
Super, thanks. While we're on the topic of upcoming trends, the next question is extremely topical, which is around W&I insurance. And Radhika, I think you briefly touched upon this during our panel discussion as well. So if I could please request you to answer this one for us. Is W&I insurance common in Indian M&A transactions, and is it worthwhile?
Sure, Nidhi. Like you rightly mentioned, I had actually touched upon this in my first answer, where we were discussing what is the alternate for a buyer if the representations and warranties are not forthcoming, the seller is not willing to back indemnities. So, like you mentioned, WNI insurance is actually gaining a lot of traction in the last few years. It is particularly relevant where the seller is a majority financial sponsor. It is relevant where where the seller's end of fund life is something which is nearing, or they are looking at a limited recourse deal or a non-recourse deal. These are the situations where you actually see WNI insurance come up in discussions, and in some cases, parties do in fact end up going and relying on this product. WNI insurance, I would say, is also extremely common in case of protecting against tax risks. Again, here you mostly see funds which are nearing the end of their fund life, or in case of tax protections where the indemnity periods run for longer. A lot of times you in fact see the buyers after completing their due diligence on the seller, etc., insisting on a WNI product rather than taking an indemnity. Another example that I have seen where WNI insurance was actually discussed right from the beginning was a sale process transaction. I can actually give you two diametrically opposite examples in this case as well. In one case where there was the company was preparing itself for a sale process, and we were helping the company get ready for that, complete the vendor due diligence, etc. The recourse being WNI was actually something which went as part of the bid draft itself, where it was proposed to the buyer that the promoter is not looking to be backing any of the indemnities in the transaction. So why don't the parties actually explore a WNI product? And we eventually, that was the recourse that was relied on by the parties. So that is one case also where in a bid process, in a sale process, where you see WNI insurance gaining momentum. Another opposite example to that, of course, would be where the seller knows that there are certain exclusions which will come from even from a WNI policy, for instance, fraud, for instance, certain risks that would not be covered by insurance. And if those are actually the risks associated with the transaction, then I've actually seen a seller, in fact, after multiple rounds of discussions, agreeing to back the warranties, agreeing to back the specific indemnity matters, because these would end up being excluded from the insurance cover. And that was a situation where, after considered discussions, the parties decided to not have and not go with WNI insurance. So, net net, I would say it is an attractive product. It is something which is grabbing a lot of eyeballs right now. It is something, and especially when it comes to tax risks, it is something that we are seeing being deployed quite a bit in the market. But two important factors to consider. One, carefully review the exclusions and highlight that to the seller and the buyer upfront. And from a seller and buyer's perspective, they should also bear that in mind, that is it actually going to be a fruitful product, or the exclusions are something which the buyer will anyway have to live with, or the seller will anyway have to back. So is it a viable product in that case? And second important consideration, of course, is the cost associated with that, because as there are no free lunches, the WNI policy does not come for free, obviously. So there are costs associated with it. There's a premium associated with it. So is it commercially feasible to use this product? And again, most importantly, who will be bearing the cost of this product?
Great. Thank you so much for that, Radhika. We have a very interesting question that's just come in with respect to earnouts. Pashupati, if I could request you to take this one. Can an earnout be paid to a company, or is this only applicable to individuals? How can a buyer pay additional consideration similar to an earnout to an entity?
That's an interesting question and a difficult one, I must say. It's very common for earnouts to be paid to individuals. However, there could be situations where earnouts are also paid to companies. Let me take one example where we advise. Now, this is a classic case of a share swap transaction wherein one of the company acquired shares of another company from an investor. The consideration was partly paid in cash and partly pursuant to issuance of securities by the acquirer company. Now, interestingly, in this case, the acquirer company was a listed company. And as we said, earnout arise on account of gap in valuation. So the listed company thought the valuation or the current stock prices were not reflecting the true valuation of the company, and therefore the deal that was structured with the seller, the securities of the listed company which will be issued to the seller will be locked in for a period of 12 months, as is the case in case of listed company. However, after the lock-in expires, the listed company itself will have a right to run a book building process, place those shares in the market to third parties. And if the seller, on selling those shares, receives an amount exceeding a particular rate of return, then the upside will be to the account of the listed company. And this is something which is regulated. SEBI came out with regulations in 2015, pursuant to which shareholders can share upside with the management. In this case, the upside itself was shared with the listed company. And since the listed company successfully managed to place these shares at a much higher, which resulted in generating a much higher return for the investor or the seller, the upside was shared with the listed company. So there are ways in which upside sharing with the companies could be structured, and this was one example. I hope this clarifies.
Thank you, Pashupati. We've got several more questions that are coming in the chat box. I'm just conscious of time. We might have to pick these up as part of the responses offline with the audience. So, like I mentioned at the beginning of the webinar, for the questions we're unable to take up, we will certainly respond offline with our responses. I think it's been a thought-provoking event, and to me, some of the key takeaways from today's webinar are that warranties and indemnities really are a package, but they're not substitutable for a robust diligence exercise. They're two sides of the same coin, and in fact, are complementary to each other. And this is also relevant when a buyer considers the manner in which disclosure letters are prepared and presented to a buyer. It's equally important for the buyer as well as the seller to look at the manner in which the disclosure letters have been shared and the manner in which risk mitigation and risk allocation is then done basis the identified findings in these letters and the due diligence exercises. I think deferred consideration structures are gaining more momentum now, more so given the overall macro factors at play. They are looked at as an effective way to bridge valuation gaps, but there are certain regulatory considerations that one should keep in mind from an Indian exchange control standpoint when structuring these transactions. And lastly, I think to my mind, the entire conversation around the earnout structures is also extremely topical in today's landscape. They are a good way to retain talent and also to optimize for the payment of the purchase consideration in M&A deals in India today. Before closing, I would like to request our audience here to please respond to the poll slide on your screen to provide your feedback on today's webinar. Team, if I can request you to please put up the poll slide now. We take this very seriously as part of our continuous improvement program. So we'd request if the audience can kindly respond to the poll here. Super. Thank you, team, for the poll. Thanks to everyone who's participated in the poll. Finally, I would like to thank all our panel members today for sharing your expertise and experience with us. You were simply outstanding. Thank you so much. Also, thanks to our audience for your attention and all your questions. I hope you found the webinar interesting and a worthwhile investment of your time. We certainly enjoyed bringing it to you. After the webinar, we will send you a copy of today's presentation, summary notes, and a link to the webinar recording. You will also separately receive a request for your feedback on the webinar. Please do take the time to send us your feedback, comments, criticism, and even compliments. The form takes less than 1 minute to complete. If you are interested in in-house training or any other matters arising from this webinar, please do not hesitate to contact us. Our contact information is right here on this slide. Thank you for your attendance today, and we look forward to being with you again at future sessions of the M&A Academy program.